After 95 years, Steamboat Willie, the first appearance of Mickey Mouse, is out of copyright and in the public domain. People are free to copy this version, not later ones, but this version of Mickey Mouse without any fear of a copyright suit. But what can Disney do to try to control Steamboat Willie with trademark law? To start, let's talk about the difference between copyright and trademark. Copyright is about incentivizing creativity. It's there to stop unauthorized copying so authors can profit off of their work. So Disney can still sue me if I were to sell copies of the Fantasia version of Mickey Mouse, but copyright has to end at some point, and Steamboat Willie's time is up. Trademark law, by contrast, is about consumer protection and fair competition. Copying is fine. It's the heart of competition, but passing off is not. So you're free to sell a sugary soda, you're free to copy the taste of Coca-Cola, but you can't call yourself Coca-Cola or something like it if it would be likely to confuse buyers. So what has Disney done? They've tried to turn the Mickey Mouse from Steamboat Willie into a trademark, a source identifier, which is why you may see it at the beginning of some Disney films. And they even got a registration for that mark. And Disney has said that it plans to enforce its trademark rights to the extent that it can, warning that it will work to safeguard against consumer confusion caused by unauthorized uses of Mickey and our other iconic characters. So does that mean it's trademark infringement to distribute copies of Steamboat Willie? Can Disney claim that I'm passing myself off as the source of the film? No. That's the point of a Supreme Court case named Dastar. There, the court ruled that when federal trademark law, also known as the Lanham Act, creates a cause of action for creating a likelihood of confusion about the origin of a good, what the statute is talking about is who is the source of the physical good, not its intellectual content. The logic is that when we see Coke, we think about the source of the physical liquid about to rot our teeth. We're not thinking about the Confederate druggist who came up with the first version of the Coca-Cola secret formula. We're thinking about the book's publisher, not the author. We're thinking about the movie studio, and not the director, screenwriter, editor, stars, or any of the many, many people who may have contributed to the film's creativity. But don't we care about this kind of source? Don't we care about authorship? Of course we do. But the court thought that copyright law protects that interest, and we don't want trademark law to become a form of what the court called a mutant copyright that, unlike copyright, can potentially last forever. So given all that, I can post a copy of Steamboat Willie online, as many, many people have. I can sell copies of the film under my trademark, but I can't do it under Disney's. But does that mean I can slap Steamboat Willie's Mickey Mouse on a coffee mug and sell that? Probably not. Although people may not buy the mug because they think Disney is the physical source of the mug, they might still think that Disney authorized or approved it. Now, I don't like this, and it's contrary to the purposes of trademark law and the logic of Dastar. It would let Disney stifle competition and raise prices for something that is in the public domain and therefore free for people to copy. But the Lanham Act also has language about likely confusion of approval. More important than that, people just have a general intuition that unauthorized merchandise sales would be unfair free riding on the work of trademark holders. So courts generally allow popular brands to use trademark law to control merchandising markets. That's why Red Sox caps are so expensive, and that will almost surely benefit Disney in a case like this. Okay then, but what if I make it clear that I'm not sponsored by Disney? Or what if I turn the Mickey Mouse from Steamboat Willie into a pattern? I don't know. I should win, but it's hard for me to be sure ahead of time that I would, and even if I do, I may still have to spend a lot of money on lawyers first. So let's start with a disclaimer art, assuming that having a disclaimer doesn't kill the appeal of the design in the first place. Turns out there's a lot of trademark cases out there where courts dismiss the presence of disclaimers for being too small or hard to notice, or maybe that third parties wouldn't notice them, leading to third parties being confused. And as for the pattern, a court might still be convinced that potential purchasers think that Disney must have given me permission to use their trademark, and that mistake is enough to support a finding of trademark infringement. Again, even if I win in the end, if a court is convinced that people are not likely to be confused, there still might be a lot of expensive litigation between now and then, so I'm not really likely to engage in this kind of activity. Now, of course, I could get more elaborate with my use of the Mickey Mouse image, and if I do, things become easier for me, but then the product is likely to be a good deal less appealing. And this is where defenders of Disney's rights may jump in and say, aha, doesn't that mean that this is the kind of thing we ought to be able to control, since the appeal of the product is its connection with the work that we created, i.e. Mickey Mouse? And yes, you can make that argument and people believe that, and that's part of the whole free riding rationale for protecting merchandising rights. But on the other hand, isn't the whole point of copyright expiration that I get to use public domain material without having to jump through these kinds of hoops? Okay, so that's the debate. And so it is with my coffee mugs. Even though they're based on a design that is out of copyright, and I should be free to sell them, it may very well require a fight if Disney is in a litigious mood. And that's life in the public domain.